Good afternoon, everyone. I am Don Bautista, the Executive Director of AC Friends of Court. We assist the public in completing legal forms. Particularly everybody in the province during these days of the pandemic, we have actually noticed when we do intake how stressed they are. And because of that, we decided what we were going to do was to interview the chiefs of our courts, as well as the chairs of our tribunals and boards, just to give them a chance to find out the behind the scenes work that's been taking place. So we have today three objectives. The first is to inform the public of the planning that's been going on with our interviewee, as well as the thinking behind the planning. Secondly, to find out what things they're doing to sort of even the playing field, as there's a fairly high proportion of self-represented litigants that appear before them. And thirdly, is to just share the reflections of the lessons that they've learned in sort of keeping the tribunal open. Our guest today is Diana Juricevic. She is the chair of the British Columbia Human Rights Tribunal. Good afternoon, Diana.
Good afternoon, Dom.
And before I ask you my four questions, I wanted to provide you an opportunity to just address our viewers and just tell them what's been going on.
Yeah, I'd be happy to. So we at the Human Rights Tribunal see ourselves like an emergency room in a hospital. And we really do recognize that people come to us in their time of need, and they are genuinely experiencing their emergency. So we want to honor that and want to do everything we can to be as responsive as we can to the public that we exist to serve. So in terms of what we've been doing over the last years, so this is before the pandemic, we've been trying to move forward with some important access to justice initiatives, which I will go into some detail in our call today. And the pandemic has just kind of moved that into high gear as we recognize that, and we'll talk about this soon with technology, that we want to make sure that technology isn't another barrier to access to justice, and that we can do everything that we can to make sure that this digital divide that exists in this province doesn't pose additional challenges for people who are coming to us in their time of emergency. So I'm happy to get into some details of what we've been doing, but I'm happy to do that in response to the questions that you'll be asking.
Thank you. So let me start off with the first one. I recognize 2 months is a short time, and yet everyone has worked hard to keep their doors open, so to speak. And that's easier said than done. There's a lot of things that have been going on in the back end, but most importantly, once we get past the triage of the emergency room, as you call it, there must be some lessons that you and your colleagues have sort of picked up that maybe will extend beyond this pandemic, and I wanted to find out what your views were.
Yeah, we'd be happy to. So we've learned so many lessons. The first being is that we really need to reach out to our parties in their time of need. And so this brings me back to our access to justice goals and the work that we've been doing over the last year. It is aligned around three values and principles that we have. One is to be human, two is to be simple, and three is to be purposeful. So this pandemic, for example, underscored the need to just pick up the phone. We can't just be pushing paper down the line. We have a party coming to us. If we can't reach them, pick up the phone. See how we can help them. You mentioned with the AC Friends of the Court helping people with their forms. We've been reaching out to parties, to the Community Legal Assistance Society, to bring them in to support parties in our process. So I just wanted to honor Dr. Henry's words because she's also been spiriting our tribunal forward, this idea of being kind, being calm, and being safe. And so we want to be kind to all parties in our process. We want to be a calming and restorative place for them in their time of need. And we also want to be a safe process. And so there are three real moments of time that we've been focusing on in this pandemic. The first moment in time is how do we welcome complainants into our process? So those who are filing a human rights complaint, what does that first moment feel like for them? How do we reach them? What do we say? The second moment in time is how do we welcome the respondents into our process? We do recognize that for many of them, it's very traumatizing to be named in a human rights complaint. And so we want to reach out to them with a phone call. And that's been something that we've been doing, just saying, we want to acknowledge you've just been served. Let's explain the process. Here's how we can move forward. And then the third moment in time is how we bring them together. So how do they want to move forward with their process? A complainant can choose to participate in mediation, which is what we've been offering throughout. And the only piece that's changed with this pandemic has been we had to move all of them to telephone in the short term, but we continue to offer the same volume, the same kind of service as before. And the second way in which we bring them together is through adjudication. So if they would like to adjudicate their human rights complaint, how do we make that process as simple, human, and purposeful as possible? So that, if anything, this pandemic has brought our team together to really focus on some very key moments in time, and how can we make those moments for our parties kinder, safer, and simpler.
Thank you. That leads me to sort of think about technology. But before I do that, I have to say, you are the 10th person I've interviewed, but the first one who's actually said we actually pick up the phone to reach out to both parties. Because oftentimes the way our justice system is, it's the users, the parties that connect, like it's an inbound thing. Nobody calls out, except you do. That is your practice. And I wanted to say that we acknowledge that. I also want to say that I think for the last maybe 3 or 4 years, we continue to receive referrals from your case managers, and we try very hard to assist them because we think that it matters that they are prepared by the time they appear before you. So thank you for continuing to trust AC Friends of Court. So my second question is about technology and why technology cannot be seen as and felt as a hurdle, especially during these times. And yet I'm hard pressed to think of any court or tribunal who's not relied on technology just to get past through the pandemic. So what's going on with the Human Rights Tribunal?
Oh, so this is the piece, Don, that I can tell you keeps me up at night. We are very aware of how vulnerable our public is and the digital divide. And that if anything, this pandemic has made that digital divide bigger and more urgent for us to deal with. So I can tell you, I'll talk about some big picture things that we're doing behind the scenes. So there is a group of us in the administrative justice sector that is coming together around this crisis and trying to pool our resources to support this public. And so I'll give you one recent example. I've been working with the head of courthouse libraries to see if we can create safe hubs around the province, including at our tribunal, where anyone who needs to access a court proceeding, whether it's at our tribunal, provincial court, BC Supreme Court, wherever, could get access to a computer, a phone, an internet connection. So that is our commitment to the larger justice community of which we're a part, to make sure that we can transform this pandemic into an opportunity to bring people together and to give them access. As you know, it's a luxury for many of us to be able to work at home. That in and of itself is a luxury. What that means is that the real estate, the tribunal itself has been largely empty. And so there's a real opportunity there to give access to the public to that space so that all they have to do is show up, and we will provide them with the technology that's necessary to have them honor the rights that they're seeking to honor in whatever process they're seeking to do it in. So that's the kind of big picture work that's being done behind the scenes right now, and we are fully committed to roll up our sleeves and figure out how we can be part of that solution. In terms of the Human Rights Tribunal, what we've done with technology is we have honored the fact that most people can use a phone. So we will give them whatever kind of process we can give them that best meets their needs. And so if they want to participate in a mediation and the only way they can participate is by phone, then we're going to do a telephone mediation. We have continued with our hearings. We've had to do them by video, but we have had parties attend the tribunal. We followed the safety protocols, given them a room so that if they don't have access to technology, they can sit in that room and participate in the video hearing. So we are really trying, and I feel like we're like the little engine that could, because we're not that big, but we're really trying in whatever way we can with every single party and complaint that we have with us to find a solution that works for them. It could be as simple, and this is a piece with this technology that we're still working on, is how do we exchange documents? So for those parties that want to go to a hearing and we're going by video and they're okay with that, how do we get the documents? How do we ensure that a party can speak to their advocate? So if we are doing a hearing and people have to go and have confidential solicitor-client privilege communications, how can we facilitate that? So there's a lot of opportunity to transform this technology hurdle into a way of bringing people together. And right now, what we're trying to do is just keep it as simple as possible. And the phone has been the simplest way. And also opening up our doors to allow people to walk in and use a safe space for them to use our technology to participate in the process. But it does keep me up at night, and it's the one piece that anyone I've spoken to in our justice sector is still struggling with how to bring us to a place of equilibrium, a place that will feel okay. And I know a lot of the tribunals don't feel okay. At least those of us who serve a very vulnerable population don't feel okay with where things are at.
It does open up possibilities. I'm going to use my favorite A word, which is asynchronous. And I've kind of pushed the two chief justices and the one judge to consider, when I asked them, hey, what's the current regular courthouse hours? Which led us to that conversation, can we rethink this past the pandemic, where we extend the hours, where we acknowledge that the normal hours don't work for everyone, particularly the vulnerable who hold two jobs, who have children. And so I have to ask, would the Human Rights Tribunal consider, or is it considering a different way of delivering your service so that it recognizes that unique circumstances of some, that they might ask for unusual hours? Would you consider more flexible hours?
Absolutely. So let me explain or explore how we've done that. It's been with our members and our mediators. So I can give you two examples. One is, whenever I've done a mediation, I will support the parties for as long as necessary, whenever they need it. So that will bring me to supporting them at 7 o'clock at night, 8 o'clock at night, over a weekend. I will speak to them or connect with them in whatever way they need. So that, in a mediation, is what our mediators are expected to do, and what many of them do. The other piece is, I have run hearings. I did one where I actually ran it on a Sunday, and it had to do with a complaint of sex discrimination, and it was one of the parties had recently given birth, and so she and both parents were working, and she needed some accommodation, and so that was our way of supporting her, which was ensuring that we were able to get her evidence at a time that worked for her and her family. And the other thing that we've done is we have supported parties to actually use video conference when they wanted to, because they might have, there might have been people at home that they needed to look after. It could be an elderly parent or a child, and they weren't able to get, or they weren't able to afford the childcare that they needed to participate or travel. So in terms of tribunal members and mediators, we're very, very flexible. In terms of our registry staff right now, they do work Monday to Friday, so that's sort of the box within which I have to operate as their leader. But we are, as we speak, in the middle of another transformative initiative, which is moving to a new case management system, which is similar to the one that the Civil Resolution Tribunal uses. There's several of us, I call us the renovation tribunals, several of us in the administrative justice sector who are renovating. And so we are moving on to that system. And so we're hoping that we can capture, to the extent that it's appropriate, the spirit of that kind of service, which is very much focused on the public that we exist to serve. And we want to do that. And that is the future, I think, of the justice sector, is really responding to the needs of the public we exist to serve.
Now, earlier, you made reference to the vulnerable. And there are two groups in our universe that I wanted to talk to you about. The first one seems to be those who are not able to use a computer for one reason or the other. And in the past, they've relied on public intermediaries, the trusted ones like community centers and libraries, who are still, by and large, closed. And those that are opening, I hear Vancouver Public Library, just blocks away from your office, has made available some computer space. But this is still a challenge. What has the uptake been like just using the phone?
For us, it's been very effective. So one of the things that we've done, especially in those moments of time when we are gatekeeping, because that's that moment in time when we are most at risk of causing harm, right? If we gatekeep in a way that keeps people out who should come in, we're really, as part of our access to justice work, as part of our work with artists, Wacom in expanding our vision, it's really looking at those moments in time. So what have we done, by way of example? In that screening process, we used to be very formal, very court-like in terms of, you give us something in writing, we assess it against a standard, we identify what didn't work and give you another opportunity to tell us in writing what it is, and then decide whether we bring it in. We are now exploring picking up the phone. So we give someone a space to tell their story. We look at that, and if there are pieces of that story that we need to hear in order to move this person through screening, we pick up the phone and we call them, and we give them an opportunity to tell us what it is. And then we capture what they say in the letter that we then send to them to make sure that what they said and what we heard is the same thing. So that is one little access to justice moment that I think is more human, because the part of what we're experiencing with our tribunal is people have different ways of expressing the impact of something on them. And it is false to assume, or it's a mistake to assume, that people can express themselves in writing. And given the vulnerable population that we deal with, it is disproportionately negatively impactful on them to assume that they can express themselves in that way. So we are trying to create a safe, fair place where people can express to us what happened to them. And we also work, we mentioned to you, earlier, Don, that we send stuff to you. We actually will reach out to the Community Legal Assistance Society, and they've had a walk-in clinic on our at our location for years now, where we will say, I think this person needs some assistance, because that is their role as well. And I think one of the challenges in our sector is everyone's very siloed, right? Everyone has a certain mandate, and these mandates operate in silos. And so we are really trying to embrace this no wrong door approach with our new officer of the Human Rights Commission, to sort of say, okay, you're coming to us, what do you need? And if we technically can't support you, right? Because we're the neutral, we can't be the advocate, then we will reach out to the advocates to ensure that you get the support you need to bring your case with us. So that's the proactive piece that we're doing, and we're trying, and it's a work in progress, but that is very much the essence of what we're trying to do with our access to justice work.
So going back to this piece that you said, you will write the party a letter to say, from our conversation, this is what we heard. Is this correct?
Yeah.
Now, how many back and forths will that take, and would you limit that?
We haven't limited it now, but we have. It's usually one, but it's a phone call where there might be 7 or 8 questions that we need them to answer, and it may be that we leave a voice message, they leave a voice message, so we make sure that we will connect with them. So we don't have a rule on our end. The goal is to be fair and accessible, and make sure that they have a meaningful opportunity to be heard. And we also want to make sure that we haven't misheard anything. So we do give them an opportunity to correct anything that we may have gotten wrong. And we're trying to do it in a way that's more human, because we appreciate that when you are, the legal language can feel very clinical. And so it's very hurtful for someone to hear, we might say, you haven't given us enough information to explain nexus. And what they hear is, you don't believe me. And that's not the message we're trying to convey. And so there's a lot of work, I think, that we in the legal community need to do in terms of being more human. Because ultimately this is their crisis that they're coming to us to help resolve in a fair way. And that is another thing that keeps me up at night. And it's a work in progress, but I'm really proud of our team at the tribunal, because this is something everyone has recognized and we are rallying behind. And so we're taking a step forward, and we might stumble and we might trip, but we're definitely moving in this direction. And it's something I'm really proud of for our team.
Yeah, the other group that's near and dear to our hearts are the victims of gendered violence, who have a presence in your tribunal matters. Internally, we've been saying they're there, but we don't find them, we can't find them just yet, because they can't leave their places because of the pandemic, and yet they're living with their abusive partners, and this makes it more challenging. I'd like to ask, and you can let our viewers know, what accommodations do you make for victims of gendered violence?
Yeah. And Dom, I will say whatever accommodation is necessary. So one of the things that we do is we will identify parties who are at risk. And so this is one example of a party who's extremely vulnerable, a person who's extremely vulnerable. They may come to us, and it may be in the context of a sexual harassment complaint. We've had extreme forms of sexual violence, and you've seen a couple of those decisions. They were published. Others get resolved in mediation. But what we will do is we will, for example, in a mediation, I will call way ahead of time. I will see if this person needs representation to help empower them. We infuse our process with trauma-informed practices. So everything from how safe is this process? Are you comfortable with me supporting you as a mediator? What can I do to make sure that you have enough supports in place? Even providing information about the crisis line or what other supports that this person may need. Make sure that the process that I can offer them honors the place that they're at and does no harm. And that may mean taking as long as necessary. Like, I've supported parties where it's taken 3 or 4 or 5 months of a mediation to get to a resolution that works for them. So what they hear from me is I will work as hard as I need to for as long as necessary to support you, to ensure that this process empowers you. in whatever way that looks or feels like for the person. If it is the respondent who is the source of that violence or that threat, then something as simple as the parties are never in the same room. It may be, and we have recently had experiences where the parties really like telephone because they're not even in the same location. Because before, when we did in person, we would keep them in separate rooms, sometimes exiting or entering from separate areas. But there was no guarantee, you know, down on the street that they may not bump into each other. So we will do telephone if that makes people feel safer. But we'll also reach out to support organizations like a TIRA or class to ensure that that person has a support person with them to help steer them in whatever way or whatever supports they need outside of that moment in time when we are engaged with them. So, you know, if I were to say I've done, like, let's say over 500 mediations, they're all completely different because they are all tailored to support the parties that we exist to serve. But whatever that person needs and whatever trauma they've experienced, our goal is to be a restorative place for them and ensure that our process does no more harm to what they are currently experiencing. And if we identify additional supports, then we make sure that we put them in touch with those other places that can support them in the other work that they need to do in order to heal from this experience.
Which leads me sort of to the third part of my second question. Can you address privacy, security, safety?
Yeah, so we are very alive to those concerns. And I have an image in my mind of a hearing that we did a few years ago that felt like a fail because we didn't provide the safety that we needed to for the parties. And we learned a lot from that hearing. So in terms of what we do have safety protocols in place. We do have a contact, like a security contact that we reach out to if we have concerns. But that all feels quite clinical, and I know that a lot of tribunals have it. So in terms of, at its very essence, what we do is we, in every case before us, are trying to strike the right balance between the open court principle, which is the one that we have to honor if we're doing a hearing, and the privacy interests of the parties. And so how does that look and feel in the context of a hearing? It can look and feel like various limitations of publication. So it could be an anonymization order. In our rules, so we honor the privacy of the parties by not publishing the hearing list until 90 days before hearing. So we have kind of our rules and process in place that strikes that balance. And we know that our process is less transparent than what many would be used to in the BC Supreme Court, for example. So we recognize that. On the mediation side, we have so much more flexibility. They are by design confidential without prejudice and voluntary. So that process is one that we can tailor and deal with all of the privacy safety issues that you've alluded to in your question very flexibly and nimbly to the parties. On the hearing process, and that example that's in my mind of what I would call the fail of our tribunal, we were a bit more constrained because the other tricky thing with our tribunal is our hearing rooms are like large boardrooms. And so they didn't have the same infrastructure that courts have to provide the level of security that was necessary for that proceeding. And if there was anything that I learned as chair during that time, is that for those kinds of cases, I should pick up the phone and I should call a court and see if we could hold the hearing there, because we just by design don't have that infrastructure in place to provide that level of security. So that is a lesson, and I'd say on the adjudication front, it's a work in progress, but we're very much alive to balancing the privacy rights of the individuals before us and our obligation as part of this justice system to honor and support the open courts principle.
My third question is about leveling the playing field. So let me start by asking maybe the easy one. How many self-represented litigants on a percentage appear before the tribunal?
That's an excellent question, Don. And so I'm going to give you my impressionistic evidence. And I know that in our annual report, the annual report will report the accurate statistic, but my impressionistic evidence is between 50 to 75% of our parties. So a lot. And in fact, our process is designed with that spirit that the public who we exist to serve largely are self-represented, largely are really vulnerable, and how do we offer them a process that gives them a meaningful opportunity to be heard in their emergency and does no harm. So that's what we try to do. But we are definitely a self-represented, party-driven tribunal.
When the other side is represented, let's talk about sort of the evening of the playing field. Procedurally, are there things that you do to try and help a self-represented person? Are there things that you would, I mean, you did mention you want to be seen as being thoughtful. And so from case management and so on, you've started to, I guess, give the impression to self-represented parties that that's the way you're wired. But what else is there? You've identified trauma-informed practice. And so there are things that the Human Rights Tribunal does, being a client-centered tribunal. And I wanted to sort of ask you, what else is there that's available to self-represented parties?
Yeah, and I would start answering this question by just acknowledging we recognize that everyone wants to be treated fairly. So sometimes we will be criticized by one party or the other by saying, whoa, you are bending over backwards to help this side, right? And so we just, and what we say in response is we're not bending over backwards. We are trying to level the playing field, or to translate into something very tangible, let's help the parties identify the issues in dispute, right? So usually when we have two parties represented by counsel, they're competent counsel, they're good counsel. My role in that situation is more of a referee, where I just sit back. I have an expectation that they will identify the issues in dispute, that they will resolve those on consent, the ones that they can, that they will comply with their document disclosure obligations, and only as a last resort come to us to resolve a dispute, right? So that's sort of an expectation I have when I'm dealing with parties represented by counsel. When I'm dealing with a self-represented party who may, not always, may be a complainant, but not always. Sometimes it's a respondent. So a complainant might have free legal representation by very competent counsel, and a respondent is self-represented. Part of my job, and we do this at the very beginning, we bring people into a case conference, is to identify the issues in dispute, to identify process options, and to help facilitate compliance with their obligations. So we see parties in our process get stuck, and I call them pain points, like painful points in the process. So they sometimes get stuck around fighting document disclosure. And so we have to take a step back with self-represented parties, whether they're a complainant or a respondent, and help explain which documents matter, right? So for a self-represented party, it may also be, you know, you filed your complaint this big, but your lived experience is this big, but the respondents have the right to know the case they have to meet. So it's a pleasure to work with a self-represented party and a party represented by counsel, because as long as they're both acting in good faith, we get to a practical fair place with both of them. And the skills that we use at this tribunal is to, and I won't even call it active, it's more just helping explain the process, helping identify the issues in dispute, helping to explain what arguable relevance means at our tribunal. What does that mean for your document disclosure? Hey, you guys are, fighting about something on the periphery, but 5 out of the 10 things in this complaint you're not disputing about, right? The facts aren't dispute. You're arguing about the legal consequences that flow from that. So even having those conversations and having those case conferences really help bring the parties together and help manage expectations and help ensure that the process is fair to both sides. So that's how I see leveling the playing field. It's just making sure that we provide enough information, enough support, so that people understand what they need to do. And if it's a party, because we've had both of them, self-reps, who aren't complying or completely overwhelmed, we will reach out to them and we will say, what can we do to support you, right? Can we help you bring the documents in? Can we see if we can get you representation to help you with this part of the process because you're really stuck? So I don't know if that helps shed a bit more light on what we try to do to level the playing field, but we really are aware, we are very aware of the power that we hold, and we do not want to abuse that power. We are aware of the privilege that we have, and we want to make sure that our process empowers both parties and is fair. And so all of the examples I've given you are examples to try to ensure that the process is fair and is empowering to both sides. And in my mind, I see those examples as examples of sort of leveling the playing field in the adjudication context. I guess I haven't answered it in the context of mediation. That is, I would say the spirit of taking like a social justice approach to our mediations. Very aware of the power dynamics in a mediation and making sure that each side feels empowered, never forcing anyone to settle quickly, giving them an opportunity to receive independent legal advice. If we get to a place of resolution, making the call to free legal advocates saying, someone's here, but I'd like to adjourn the mediation to give them an opportunity to think about this, to get independent legal advice. So just being very aware of all of those dynamics and making sure that people feel and genuinely experience that they've been treated fairly. That's our goal.
Do you encourage self-reps to bring support friends?
Yep, absolutely. So when I do for example, in a pre-mediation call, I will ask them and encourage them to bring someone there as a support. Sometimes they want that person there in person, other times they want them over the phone. And then I just explain and have them sign the settlement meeting agreement to make sure that that support person is aware of the confidential nature of the discussions. But absolutely, anything that person needs to feel more comfortable in a process that can feel very intimidating for them.
So are there any other changes that we should be expecting soon?
Yes. So as I said, putting aside COVID, which is sort of an exogenous shock to our system, in the last couple of years, we've been working really hard behind the scenes on what we're calling our access to justice initiatives. And as I said, reimagining our process along 3 values or principles, that being human, simple, and purposeful. That has infused every part of our process, and we are trying to move our process away from something that feels like paper pushing in a court into resolution, because we know people are waiting too long and are getting stuck in too much delay. So that is organic. Every single day, every single week, there are things happening behind the scenes. On top of that, we are transforming our case management system from an old legacy system that was there for 15 years to this dispute resolution suite which is going live this month. So in a couple of weeks. And I think by July, the public will see some of that. So something as simple as a member of the public being able to see where they are in the process, where their complaint is sitting, just to be more responsive. Now that's a work in progress, because that case management system, it's a step in the right direction, but it's a marathon. And there's going to be parts of it that are going to feel like they're not accessible, and so we need to work on that. So this is the place where we want to hear from our public what's working, what's not. And then the third big piece that we've been doing is our Indigenous Justice Initiative, and that is to honor Ardith Wacom, to honor expanding our vision, to honor the over 100 voices that she honors in her report. And so we, this month, will be publishing our progress report on her recommendations. So we released the report in January, and then we are obligated and embrace that obligation to report to the public what we've done in the last 6 months to advance the recommendations that she's advancing. So much stuff happening that we're really proud of. And we would like to be an exemplar for the rest of the administrative justice community, because what we've tried to do at the tribunal is self-reflect as an institution and identify systemically what are the barriers systemically within our tribunal that are impeding access to justice, and dismantle those. And so I'm so proud of our team, because it takes a lot of courage to identify oneself as the problem, which is what we're doing, and to try to push through that problem and focus on solutions. And so I can just say, Dawn, I believe in the next 2 years to 3 years, this tribunal will be a very different one from what our public is experiencing today. And I'm really proud of that, because I believe that it will be a tribunal that is more responsive to the needs of the public that it was designed to serve. So if there's one silver lining to all the stress everyone's experiencing, it's that we are definitely in a marathon, but we are moving in the right direction.
That is good to hear. And, you know, if you're keeping to that schedule of yours, you basically said COVID or no COVID, you can hold yourselves accountable.
Yeah.
And, in the spirit of the TRC, that's fairly significant.
Yeah.
It's a significant undertaking to embrace it the way you have. We're looking forward to it. That leads me to my fourth question, my final question. You said earlier, both parties, if they're represented, works pretty easy. They've come to you because they have identified issues which they cannot agree on, and they're seeking tribunal to basically rule on it or get them to a place where they can agree to. That makes lawyers very powerful. They belong to their own bar associations, their own subsections. They acquire a certain level of expertise. They are connected to the tribunal one way or the other. So if there were things that they wanted to suggest, it's certainly a lot easier.
Yeah.
But for the reluctant self-represented party who puts them before you, not because they want to be, but because they have to. If they're not happy with what's going on, if they wanted to write somebody in the tribunal to say, hear me, these are my concerns. Yeah. How can they do that?
Dawn, that's an excellent question. And I will say the how, pick up the phone, send an email. When the doors open again, come in. And every single complaint that comes through the tribunal eventually reaches me, and I want to hear that. So we have not, so an area of our tribunal where there's a gap and we've failed and we are working on it, is in surveying the public. We just haven't gotten there yet. It's on the list. We haven't gotten there yet. But I pause here to say that what we don't want to do are those clinical surveys that don't give people a meaningful opportunity to express how they experienced our process. And so coming back to those three principles of keeping it human, simple, and purposeful, the best thing that I would love is just to share your experience with me. So what we did last year, we did it with 4 people, so sample size negligible, but we brought 2 self-represented complainants and 2 self-represented respondents who had gone through our process, reached a resolution, and reached out to them and said, would you like to talk to our team? And so last fall, we called it our sort of user experience examples. We gave them an opportunity, a full hour, to just tell our team how they experienced our process. And it was eye-opening for the team, right? Because some people said, oh, we're so great, we issued a decision, you know, within whatever, 90 days. And they're like, but I was traumatized at the beginning. I didn't hear from you guys for the first month, right? So we would like to do more of that. And we will, at some point in the near future, have something more systematic in terms of how we reach our public. But at the end of the day, what I want our public to know is how you experience our process matters. And we want to know what parts of our process were painful for you. And if you had a great, great experience, that's great. I don't need the compliments. I want to hear the criticisms. Tell me what's not working, because we can translate those painful moments into an opportunity to do better. And so the simple way today, because we don't have the surveys, we don't have the DRS case management system working, we're not sophisticated, we definitely don't have Twitter or anything like that. But the simplest way to reach us is send an email, give us a call. Our team knows to take that in and it will come to me. And then we can reflect on that and find a way to transform that into something that will help us serve others better.
Well, thank you, Diana. I've run out of questions. So I would like to give you the privilege of having the final words before we say goodbye to our viewers.
Yeah, well, Dom, I just wanted to take this opportunity to thank you and the work that you and your team are doing to support our public, because when I'm not wearing the hat at the Human Rights Tribunal, I have been wearing a hat at the Mental Health Review Board. And in that world and in those places, we see how integral it is to have people who are supporting a vulnerable person and people who can be that person's voice as an advocate. And so I think we recognize that our system is only as good as everyone who is around and supports it. And so your Friends of the Court work that you guys are doing is so incredibly integral to promoting access to justice, to giving people a meaningful opportunity to be heard. And without people like you, we have a system that is a system in form, but not in substance. So I just want to express my sincere gratitude to you and to everyone out there that's like you, that is fighting the good fight, that is going above and beyond the call of duty, that's doing everything that you can to ensure that people have a meaningful opportunity to be heard on the issues that matter to them, because everyone's issue matters, and it's their moment of crisis, and we exist to help them resolve that. And if we're not resolving it well, then we shouldn't exist. That's my view. So honesty is the centralizing principle for us here. And it's people like you, Dom, that keep the system moving and keep it working. So thank you. Thank you to the public. And it's just with incredible gratitude that I am here to speak with you today. So thank you for your time.
Well, you've certainly set a very high bar for the BC Human Rights Tribunal. I wanted to close by thanking your husband for taking your children to the park so you and I can have this very candid conversation.
Yeah, yeah, no, my pleasure. I'm sitting on the floor, and there's a kitty litter box right next to me. So,
Well, in the days moving forward, I know there's a lot of stuff that's going on at the tribunal. I wanted to, on behalf of the public, wish you well, and please convey our gratitude to your colleagues, and please, all of you, stay safe.
thank you, Dom. Have
Thank
a good
you,
afternoon.
Diana. Thank you. Bye-bye.
Bye.